walking along the sidewalk in any city in Ontario and a police officer in full uniform comes up to you and puts his arm on your shoulder and says, look, you're being detained. And you say to them, well, what am I being detained for? Do they have to answer your question? That's the question. Now, that's a very common question and a common occurrence, and I'm going to give you some examples of this, okay? So this is Kruse Law YouTube channel. I'm Mike Kruse, and we answer common FAQ questions, and this is one of them. So great question. So are the police required to advise you why you're being detained? So let's first of all define detention, which is a little different than arrest. Arrest, of course, is when they're arresting you for a criminal offense. Detention is when a reasonable person would conclude that you're not free to go. So in some manner of what the police are doing or saying in your presence, clearly if they say you're being detained, example is a detention, but there's other matters. They could be blocking your movement. They could be just stopping you. So a reasonable person would conclude you're detained. In that situation, the Canadian Charter of Rights and Freedoms, Section 10A, says that if you're under arrest or detention, and this video is about detention, restricting your movement, not arrest, the police must promptly advise you of the reason for detention. So in that particular situation, let's say the police officer received a description of a robber and you match the robber. They want to stop you and ask questions. They're not sure. They're detaining you. You're not free to go. They must advise you in that situation. Look, you're under detention because you're matching a description of robber. Obviously, in that situation, the police might even pull a gun on you and handcuff you and ask you questions. Now, they're going to ask you questions during the detention, obviously, but you have a right to a lawyer because you have a right to counsel upon arrest or detention promptly. So in that situation, my advice would be to exercise your right to silence and ask for a lawyer. If you freely answer the questions, then they can be used against you. Say you are the robber, or say you are an innocent citizen who happens to look identical to the robber and you're in the vicinity and you get charged. So you have to be very careful. But yes, under Canadian law, the police are required to advise you of the reason for detention. And this is a very important right because you have to know why you're being detained. And this, if it subsequently leads to arrest, like let's say, for example, the police start asking you questions and you make some admissions or say something stupid that makes you look guilty and they do arrest you. Well, if they never advised you upon first instance the reason for detention, it's called an arbitrary detention under Section 10A, and you may have charter rights under Section 24.2 to exclude your statement, to potentially exclude any search and seizure they do under Section 8 as well. So these are charter rights which flow. And I advise people, if you're stopped by the police on a sidewalk, to ask them, am I under detention? Am I free to go? Because sometimes the police just fishing things. They go up to people and hope that people start talking to them. This was a carding practice, you recall, in Toronto, you saw in the news, which is really unfair. And they were targeting marginalized people, like black men, for example, were getting targeted. Now they've made rules about carding that they have to advise you that you're free to go. We just want to ask questions. And if you answer questions, they're supposed to give you a card that says their badge number and whatnot. I'm telling you, don't stop. Just ask a person free to go. This was so unfair because they were marginalizing black people and Aboriginal people, Indigenous people in Ontario, and people of color. It was not a pretty picture in Toronto, and that was really, really prejudicial. So detention's an interesting thing. It's different than being arrested for a criminal offense. It's when the police want to detain you to ask you questions, but you have a right to a lawyer under this situation. That right kicks in under Section 10B of the Charter. Upon arrest or detention, you have a right to speak to a lawyer. So the police would have to give you a phone call. You don't have to answer any questions. Exercise your right to silence. Speak to a lawyer, follow their advice. But first and foremost, if the police ever stop you on the road, on the sidewalk, or anywhere for that matter, ask them if you're free to leave. That's the first thing to do, because if they say no, you're under detention and your rights kick in, and you should ask to speak to a lawyer at that point. I wouldn't answer their questions, because innocent people do get caught up in mistaken identity, in saying stupid things they didn't mean, and it's being used against them. It's, first of all, I always thought this carding was unscrupulous police conduct. It was accepted back then, but thank God they've limited it now. But anyway, that's a little bit of a primer on this, on unlawful detention and what to do, what to say. But the bottom line is the police do have to indicate the reason for detention. They don't have to say things crazy. They don't have to go into great detail, but say, look, we've been told that you're similar to a suspect in a robbery, and I'm putting handcuffs on you now, and we're going to ask you a few questions. Oh, I want a lawyer. Okay. But they're going to maybe take you to the police station then for a lawyer. But I would do it in that situation. That's pretty serious. Now, there are situations where, when you're stopped by a car, by the police, they don't, they can start asking you questions initially without telling you you're under detention. Then, a police officer can stop a car and say, give me your license, registration, and whatnot. Just to check your mechanical fitness of the car. So they don't have to give you the reason. So that's an exception. Also, they don't have to give you rights to counsel before the roadside breath test. You're under detention during that 5 or 10 minute roadside breath test, and they don't have to give you a right to lawyer during that. But the police are generally going to tell you, of course, that why they stopped you in many instances. But hey, the police in Ontario can just stop you. I just stopped you to do a registration check, license, insurance, please produce it. They do have to tell you, though, in that situation about that. But there you have it. It's a quick little primer on detention. Know your rights, know your right to silence, know the fact that they have to tell you why you're in detention. Make sure you ask if you're free to leave and follow what the lawyer says. It's right to silence. Just shut up in this situation, because we don't want innocent people getting convicted who might say the wrong thing out of the wrong circumstance. And even if you did a criminal offense, why convict yourself? Let the police convict you with the Crown. Don't create further evidence against yourself. That's an advice that any criminal lawyer is going to give you. So anyway, I hope you enjoyed our video. If you do like the video and you enjoy our video series, please subscribe, and I look forward to seeing you on the next video. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.